Thank you, Senator Villanueva. Justice, a few questions from the chair.
Yes, Your Honor.
In the previous rules of the Judicial and Bar Council, those with pending cases or pending complaints are automatically disqualified. The case in point is that case of then Senator, now Congresswoman Laila de Lima. Because of her pending disbarment case in 2012, she was automatically disqualified. But soon enough, your rules were revised. And because of that, under Section 5 of your revised rules, Paragraph B, those with pending administrative cases or complaints before any court, office, tribunal, or government office, agency, or instrumentality, or before the IBP, or any association, disciplinary committee, or body, when in the determination of the council the complaints are serious or grave as to affect their fitness for nomination, ay disqualified lamang po. But again, kung madidetermine ng council na yung complaints are serious or grave as to affect their fitness for nomination. Ang ibig pong sabihin nito, Justice, if the council feels that the complaints are not serious or grave enough to affect their fitness or nomination, hindi po madi-disqualify yung applicant. Is that correct, sir?
With respect to disqualifications, there are automatic disqualifications. Like if you have been pending cases in criminal cases in the courts. And
Yes, Justice. Sinasabi ko po yung sa Section 5, which says the following are disqualified from being nominated for appointment in any judicial post or the position of ombudsman, deputy ombudsman.
Yes,
Ito pong sinabi ko, pero ang kolatilya po, when in the determination of the council, the complaints are serious or grave. Ibig sabihin po, kung hindi serious at saka hindi grave, hindi po siya madi-disqualify. That's right, sir.
It pertains to the administrative cases po. If it is pending in the ombudsman, an applicant is automatically disqualified. But with respect to the pending administrative cases or complaints before any office, court, tribunal, or any government office, ito po subject to this discretion of each member. Yun ang
Yan nga po ang ibig ko sabihin, Justice.
hindi automatic.
Yun nga po. So, ibig sabihin nito dahil nag-file po ng disbarment si Mayor Sebastian Duterte,
Yes po.
ibig sabihin po, in the discretion of the council, hindi siya serious or grave enough. Tama po ba?
Ang what I heard yesterday was the argument that it refers the complaint refers to the same act which was in a complaint previously dismissed by the ombudsman or earlier dismissed by the ombudsman. Nag-prevail na reason yesterday. I just cannot disclose the members who gave those reasons, but it prevailed yesterday. Yes, sir.
This representation, Justice, filed a sworn opposition to the application of Secretary Remulla to the office of the Ombudsman on two grounds. Secretary Remulla publicly announced that he added restitution as requirement to the Witness Protection Program. That requirement does not exist in the law, but he insisted. That, Justice, to my mind, clearly indicates or demonstrates the lack of required legal acumen as well as adherence to the standards of probity befitting an ombudsman. Second, the Secretary's affirmation of the bending the law constitutes a violation of the Code of Professional Responsibility and Accountability. These two grounds, Mr. Justice, are not enough for the JBC to consider?
It's like this. We receive your complaint or opposition against Secretary Remulla. We considered the reasons, but there were two issues yesterday. First was whether or not he is disqualified. And then doon na pumasok sa because he was not disqualified, he can be voted upon. Pumasok na ho dun yung consideration of the merits of your complaint. Doon no, he was not able to get a unanimous vote. Pero hindi ko na ho masabi ko sino yung mga votante. But they considered the reasons you gave. Your two reasons were very important. We received them, we read them, and we considered them. But
How did you consider that?
Na.
How did the council consider this sworn opposition?
Ano yun, nasa weight na ho yun, nasa weight. Not sa qualification or disqualification, but on the weight na sa voting ng a considered candidate, nandun na sa weight to yun. The members, majority are appointed by the president. They considered that it is, they voted, the majority voted for him, so they did not give it much weight. You know, or the opposition.
Mr. Justice, one of the overarching principles that guided the creation of the 1987 Constitution is the desire to promote the rule of law, as is stated in our own preamble. Pag sinabi po nating rule of law, this is the guiding post. When somebody affirms that sometimes we can bend the law, you or the JBC took that very lightly, Mr. Justice?
No, Your Honor, we, in the interpretation of the law, we can be strict, or we can be, what you call that. For example, in the interpretation of the Constitution, if you are a strict one, they call you an originalist. And if you want to adapt to the times, they call you are a believer of the living Constitution. I don't know.
We're not interpreting the Constitution, Mr. Justice.
Yes, sir.
I'm asking you whether the rule of law is still the foundation of our Constitution.
It is very much the foundation.
When somebody affirms that the law can be bended, that is inconsistent with the Constitution. Don't you think so?
Yes, I agree with that. But sometimes it depends upon the context of how it is used, the bending of the law, whether it is freely, if they are interpreting it liberally.
Did you know how it was used, Mr. Justice?
Yes,
We were discussing
Yes,
whether
Your
or not restitution
yes, Your Honor.
is a requirement for an applicant to be processed under the Witness Protection Program.
Yes, Your
And suddenly the Secretary of Justice insisted that one requirement is restitution. It is not there.
Aware of that. Yes.
And somebody suggested that sometimes the law should be bent. That
Yes,
was
sir.
the context, Mr. Justice.
I heard it, Your Honor. I saw it on
And if you hear it from no less than the Secretary of Justice, abrogating all the cornerstones of our belief in ourselves, in our Constitution, then you still include him as an applicant to the Ombudsman. Somebody who will preside over the lives, the properties and liberties of every citizen of this country. You take light of that. The JBC will take light of that, Mr. Justice.
the majority considered it as slight.
So the majority
The majority.
took light of the opposition of a senator of this republic, Mr. Justice.
That is a fact, Your Honor.
And 6 of them, based on their discretion, the opposition is not worth it. Is that it, Mr. Justice?
There were six yes, excluding the secretary himself, because he is also a member of the Judicial and Bar Council.
Because of his inclusion in the shortlist, Mr. Justice, will you favor amending further your rules
Yes, Your Honor. We
that
have-
would give a chance that all prospective nominees or applicants to the Ombudsman should already be subjected not to the JBC, but the Commission on Appointments?
It's up to you, Your Honor.
It's only a suggestion, Mr. Justice.
But with respect,
Just thinking aloud, Mr. Justice.
yes, Your Honor. With respect to the JBC, we have set tomorrow up to Friday to review and amend the internal rules of the JBC, considering past incidents. And we are inviting the public to submit their recommendations. So it will be a 3-day workshop to amend the internal rules of the Judicial and Bar Council.
What would you think of the public thinking that somebody who affirmed that sometimes we should bend the law, has become the ombudsman of this republic.
Uh, I do not have time really to read the social media, but my position is different. I am a believer of the rule of law. I was a justice for several years at a regional trial court. When I was a regional trial court, I adhered to precedents. Also, when I was a justice in the Court of Appeals, I adhered to the precedents. When I was in the Supreme Court, whenever I make a ruling, I was very aware that our decisions will be considered as precedents by those following us. So that's my experience being in the judiciary. That's why I believe in the rule of law.
Thank you, Mr. Justice. Any more questions from the floor?
Mr. Chair.
Yes, Assistant Majority Leader.
Thank you, Mr. Chair. Good morning, Mr. Justice.
Morning.
The ombudsman position has been vacant since July 27, 2025.
In other words, the JBC is not a mere rubber stamp. Is that correct? I mean, its job is not merely to ensure that it ticks off all the requirements or deletes in the case of disqualifications. So otherwise, the Constitution wouldn't require such stringent qualifications for one to become a JBC member. Isn't that correct, Paul? Isn't it though before applicants should have already qualified on the last day of the application? I heard this is a practice for regular applicants for the judiciary, the RTC. Why change it for some people? Why does the JBC keep changing its rules? Does the JBC favor someone? Why qualify an applicant on the very last day of final deliberations? I refer to the case of Attorney Logan, who was only issued an ombudsman clearance on October 6th, the same day the shortlist was released and sent to the office of the president due to 2 pending ombudsman cases. Why were the rules suddenly changed in her favor?
Actually, Your Honor, when we publish the announcement inviting applicants for we invite the public to report, to comment, to endorse or oppose the applications of those listed applicants. Not all submit their oppositions on time. There are those who submit their clearances when they apply. There are those who reserve their, or they ask for time to submit their clearances. And after that, there are also oppositions, complaints against the applicants. And in our experience, most of the complaints they're not that serious as to disqualify a candidate. So we consider every opposition, we ask them to comment, to comply with the due process requirement of the Constitution. So they are asked to comment. The last day, because of our experience of complainants or oppositors filing their complaints and opposition during the last week or the last few days of the final deliberation, we deem it unfair if we will automatically disqualify them. So we
Justice.
have to study if the matter is very serious or not.
Yes,
Because-
Justice, but you made mention of a list of absolute requirements, which contains, among others, a clearance of the ombudsman. Surely that doesn't require an oppositor to file with the JBC. Surely that is of note. Why was Attorney Logan considered, given that the ombudsman clearance was only given on the same day, yesterday, when the shortlist was given? The deadline had long passed. Why is the JBC changing its rules to favor certain people?
It's still within the rules, Your Honor. Before the voting, they should, if they can submit a clearance, they can be qualified and can be
Even on the same day, Paul.
same day.
Because they're given to understand that the required documents are supposed to have been submitted in September, as is usual with regular judges in ordinary courts.
Yes. With respect to judges, we have considered it to be the last day because there are so many good judges
So there's a distinction po.
When
The
they ask-
ombudsman is special and regular judges have to comply with the rules.
No, they have the same qualification if they have a
But
pending.
there was a deadline for the requirements to be submitted in September,
Well-
a deadline that was actually extended repeatedly.
Yes. It is on the last day of we call it the final deliberation. If they can submit a clearance, they can be considered with respect to.
Several dates were given po. In
Yes,
September, I recall.
Yes, Your Honor.
In any case, did you participate, given that you were reappointed twice? Did you participate in the proceedings in the shortlisting of the ombudsman candidates po?
Yes, yes, Your Honor, because my appointment was ad interim.
So, given the two appointments, you in fact participated. So we are very curious about the occurrences with regard to the JBC shortlisting yesterday. It is very clear that the JBC requires that an applicant should have no pending administrative or criminal case before any office, considering that Secretary Boyeng Remulla was included in the list of nominees, despite having pending cases and issues touching on propriety. Would you agree that such inclusion may cast doubt on your council's adherence to the constitutional requirement of recognized probity and independence?
We were aware of that. Senator Pangilinan was there, and Congressman Luistro was there when we considered the first issue of whether a candidate is disqualified or not. So in the case of Secretary Remulla, he was able to submit clearances from the ombudsman. And then we checked the JBC rules, and in the JBC rules regarding disqualification, if you have a pending case with the ombudsman, you will be disqualified. But if there is any other administrative case before any other government agency, it will be subject to the discretion and evaluation of the individual members. It is only, I do not know why the administrative cases of pending before the ombudsman are different from the other agencies, but that is the rule. And
But surely you're aware that the pending cases were not merely administrative, but in fact criminal. And we can hardly say that recognized probity is in fact upheld.
Mr. Honor, that is, we are aware of that, but he was able to obtain a clearance. So,
As a matter of fact, some of these cases arose before Secretary Remulla made his intentions known that he intended to become ombudsman. Is this a person of recognized probity? Also, a lifelong politician? Is this a person of recognized independence?
the voting yesterday was in secret, it was confidential. We do not know the members who voted for him and the member who did not vote for him. So may we ask your indulgence on that? We respect the confidentiality of the JBC proceedings because the Chief Justice, Alexis Mundo, even asked us to execute an undertaking that everything should be confidential for the protection of the members of the JBC, especially the regular members who are not politicians. They are apolitical.
We are certain that you are aware that in 2012, for the position of Chief Justice, two pending disbarments against then Laila de Lima disqualified her.
Before you answer, Justice, the chair would like to acknowledge the presence of Senator Joel Villanueva.
Yes, so this occurred in 2012 when she was disqualified
Yes.
because of two disbarment cases. I am certain that you are aware that there are disbarment cases filed against Secretary Remulla. First, on the 23rd of September, Attorney Topacio filed. Thereafter, on the 2nd of October, acting Davao City Mayor Baste Duterte also filed a disbarment case. In addition, our chairman, Senator Marcoleta, filed his sworn opposition. But in the shortlist submitted yesterday to the Office of the President, it still included the name of Secretary Remulla. Why is that so, considering that there are two pending disbarment cases and a sworn opposition?
We considered them as complaints, but in our discussion yesterday, it was considered that last-minute oppositions and complaints were considered as mere oppositions by the JBC.
Are you saying, Justice, that all of these cases against Secretary Remulla are entirely baseless?
No, it's still ongoing, but in the minds of the members, they were.
You admit that they were still ongoing, certainly.
Yes, yes,
Uh,
yes, Your Honor.
You can hardly say that he is qualified. You yourself said if there are pending cases, and
Yes.
you said that they are ongoing.
Ongoing.
How could you have disregarded them and included him in a short list?
Uh,
You can form your preliminary judgment or opinion on the cases for purposes of JBC proceedings, right?
Yes,
Are we saying that these are baseless? Is it not clear that the case I filed at the Ombudsman was dismissed by the acting Ombudsman Vargas on the sole ground that the Supreme Court would raise prejudicial questions? Certainly, the Ombudsman didn't tackle the merits in any way. Hence, the JBC should have considered it and given it more weight.
was considered by all the members of the JBC, but we do not know the reasons of each and every member. The
What were
JBC,
your reasons as a member? How did you justify his inclusion?
he was able to secure a clearance with respect to the criminal cases. And then with respect to the disbarment, they were considered one and the same act by the body. The members of the JBC come from different interests. I represent the retired justices. One represents the academe, one represents the private sector, and one represents the IBP. The government is represented, the Senate is represented by.
Sir, we're aware of the different sectors represented in the JBC, and we are certain that they're all qualified and
Yeah.
fit. However, given the cases that were pending, what will happen as a former Supreme Court justice if the Supreme Court decides that no prejudicial question exists and that the Ombudsman should have resolved the Remulla cases on its merits? Do you think that Secretary Remulla can ever be fair in deciding the cases against himself, now sitting as Ombudsman? If he inhibits, do you think that it will allay any notion of partially considering that it is still his underlings who will finally decide? Does that not put us in an untenable position?
Yes, Your Honor, I agree that he has to inhibit himself, but he's in a position to, as the Ombudsman, yes, he is in a position to influence the deputies if who will replace him if he inhibits himself. But there's so many factors, and we cannot at this time predict what those factors are. But the human factor is very important. Their background, their sense of justice, like that.
Would not that be the same problem if the decision on the two disbarment cases is adverse to Secretary Remulla? How can it be enforced, considering that he is an impeachable officer? Did the JBC not take this into account?
We took this into account, Your Honor. We know that there is a process. With respect to disbarment, sometimes they are directly filed with the IBP, and then it is referred to the council or the committee in the IBP, and then if they have finding already, it will go to the Board of Governors. And all their findings are recommendatory. It is after the Board of Governors of the IBP, they will recommend to the Supreme Court. The Supreme Court will be the final arbiter.
Yes, Justice Mendoza, we're aware of the process. Merely that it appears that the JBC did not adequately take into consideration all these issues. We are aware, Mr. Chairman and Justice Mendoza, of the tremendous pressure upon the JBC. However, it's apparent that the JBC subverted its own rules and really performed extraordinary leniency in the case of at least two applicants, by which we're totally perplexed and rather alarmed for its future performance. That's all, Mr. Chair. Thank you very much, Justice Mendoza.